Thank you for joining the press conference to discuss the Independent Resolution Panel's decision regarding Louisiana State University, case number 00909. We appreciate everyone's patience and flexibility today as we work through some technical issues. Please note that everyone is in listen-only mode. After the chief panel member provides his remarks, we will move into the Q&A portion of the call. As members of the media, you should have received a link in both the news release and the public decision, and the public decision contains the details of the case. These materials are all available on the IARP website at iarpcc.org under referred cases. And now I would like to introduce Wendy Walters, NCAA Managing Director of Hearing Operations and Infractions Appeals Committees. Wendy?
Thank you. Before we begin, we want to first provide a brief overview of the Independent Accountability Resolution process. The Independent Resolution Panel is part of the NCAA's Independent Accountability Resolution process, or IARP. The IARP is responsible for reviewing select complex Division I infraction cases with the goal of increasing accountability in intercollegiate athletics by creating an alternative to the NCAA's peer review process. Once a case is accepted into the IARP, an independent resolution panel is appointed by the IARP's Independent Accountability Oversight Committee. The hearing panel reviews the allegations, the institution and any involved individual's responses, the complex case unit's reply, and conducts a hearing with the parties. Following that hearing, the Independent Resolution Panel will deliberate and determines whether violations occurred, determines the level and classification of the case, and prescribes the appropriate penalties. Decisions issued by the Independent Resolution Panel are final and are not subject to appeal. The Independent Resolution Panel members for this case were Bruce Meyerson, a retired Court of Appeals judge, an adjunct professor, a mediator, and an arbitrator, and chief panel member for this hearing panel. Jody Balsam, a law professor at a non-NCAA institution, Bernetta Bush, a mediator, arbitrator, and retired judge, Corey Jackson, a chief human resources officer. Chief panel member Meyerson will now discuss the findings, conclusions, and decisions of the Independent Resolution Panel. Following opening comments, he will take questions. Please note that the hearing panel's decision stands on its own merits and again is not subject to appeal. Judge Meyerson, please begin.
Well, thank you, Ms. Walters. And first, let me apologize for the delay here. The technical difficulties were at my end, so not at the NCAA end, so I do apologize. I'm going to go ahead and read a preliminary statement that will provide you with an overview of what this case was about and the panel's decisions and imposition of penalties. So let me go ahead and do that. It's quite lengthy, so I hope you'll bear with me. So the Independent Resolution Panel's decision details the findings and penalties in this case. You should have access to the decision itself, but I will provide a brief overview and answer after I finish my remarks any questions that you might have. My comments today are designed to provide an overview of the case. However, the case stands on its own merit. Obviously, nothing that I say can vary the actual decision that the panel reached. I want to remind you also that violations in this case were the result of decisions and actions within the football program and the men's basketball program at Louisiana State University. The hearing panel prescribed penalties accordingly. The panel was intentional in not prescribing penalties that would have a negative impact on current student athletes. The panel also applied significant weight to LSU's self-imposed penalties, especially the 2020-21 postseason competition ban for its football program. LSU imposed the postseason ban in December 2020 at a time when the football program would have been eligible for a bowl game. That decision resulted in student athletes not participating in a postseason bowl game, and also resulted in a significant financial impact to LSU under Southeastern Conference policy. The NCAA membership has acknowledged the significance of these self-imposed penalties, and the hearing panel encourages NCAA member institutions to critically examine meaningful and proactive self-imposed penalties based on their evaluation of the severity of the violations. This infraction case consisted of violations occurring from 2012 through 2020 in the football and men's basketball programs and involved numerous procedural requests. In addition, in my capacity as the chief panel member, I resolved multiple procedural issues, primarily related to the complete and timely production of records during the investigation. The details can be found beginning on page 5 of the case decision. Allegations in this case involved the former head men's basketball coach, a former assistant men's basketball coach #1, and the institution. Note, the assistant coach alleged to have been involved in violations later became an associate head men's basketball coach after the allegations time period and prior to his departure from the institution. Ultimately, the hearing panel identified violations related to the former head men's basketball coach and the institution. So let me go ahead and begin with the information in the decision related to the football program. The football program portion of this infractions case involved the provision of impermissible benefits by 2 LSU representatives of athletics interests and an impermissible recruiting contact by the former head football coach. A portion of the football conduct in this infractions case came to light through disclosure in a federal criminal investigation of a money laundering scheme related to representative of athletics interest #1 for the LSU football program. In or about 2012 and continuing through 2018, representative of athletics interest #1 was a resident of Baton Rouge, Louisiana, and was previously employed as the president at a not-for-profit foundation. During this time, he was also a representative of athletics interests for LSU's football program as a donor to the Tiger Athletic Foundation and an LSU season ticket holder. Representative of athletics interest #1 was introduced to the parents of former football student athlete #1 in 2012 or early 2013 by the LSU Assistant Athletic Director of Football Operations. Representative of athletics interest #1 offered to employ both the former football student athlete's mother and father. On February 16, 2012, representative of athletics interest #1 paid the father of former student athlete #1 $3,150. This was followed by recurring monthly payments of $3,000 for nearly 5 years as a retainer from the foundation. The total value of the benefits provided to the father of former football student athlete #1 was approximately $180,150. However, the father worked no more than 5 events during this time. Because the father received payments from the foundation for work that was not performed, the hearing panel determined these payments to be impermissible extra benefits to the family member of a student athlete. The father received these impermissible extra benefits from February 16, 2012 through January 2017, making former football student athlete #1 ineligible to compete in 50 contests during this time. The institution did not become aware of nor report the situation to the NCAA until November 2018. Because a former representative of athletics interest number one status as a representative of athletics interests of LSU, the institution had a heightened obligation to monitor his interactions with any student athletes or their families. It failed to do so. After its assessment of the facts, the hearing panel found this to be a level 1 violation. Additionally, on January 17, 2019, former head football coach had an impermissible recruiting contact with 2020 football prospect student athlete in the office of the prospective student athlete's high school coach. During the meeting, the former head football coach engaged in dialogue in excess of a greeting and did not take appropriate steps to terminate the encounter when he discussed recruiting with the high school coaches in the presence of the prospective student athlete. Further, the former head football coach invited the prospective student athlete to the institution's junior day. Because this meeting occurred prior to July 1st, following the completion of the prospective student athlete's junior year, the hearing panel found that the former head football coach was in violation of NCAA bylaws governing impermissible recruiting contacts. After its assessment of the facts, the hearing panel found this to be a level 3 violation. Finally, as it relates to football, on January 13, 2020, following the college football playoff national championship game, representative of athletics interest number 2, who was also a former football student athlete, provided a total of $2,000 in cash payments to 4 football student athletes. Because representative of athletics interest number 2 is a representative of athletics interest, the cash payments violated NCAA bylaws governing extra benefits provided to student athletes. Once again, LSU had a heightened obligation to monitor the activities in and around student athletes in a celebratory atmosphere, the winning of a national championship, where individuals may be eager to reward student athletes for their performance. LSU failed to do so. Therefore, after its assessment of the facts, the hearing panel found this to be a level 2 violation. Let me turn now to the men's basketball program. Initially, information regarding potential violations in the men's basketball portion of this infraction case arose from the United States District Attorney's Office in the Southern District of New York involving a scheme within men's college basketball. However, a majority of the allegations put forward by the complex case unit in this infractions case were not related to activities in that Southern District of New York matter. So let me begin by talking about the portion of this case that concerns the former head men's basketball coach. The former head men's basketball coach had developed a close relationship with a former men's basketball student athlete he previously coached at another Division I NCAA institution. In June 2017, this former men's basketball student athlete at NCAA Division I Institution A sustained injuries ending his professional basketball career and encountered difficulties financially supporting himself, a former fiance, and their child. July 25th, 2017, the former head men's basketball coach exchanged several text messages with the former fiance of this former men's basketball student athlete. Also on July 25th, 2017, the former fiance and the former head men's basketball coach spoke on the telephone. The next day, the former head men's basketball coach retained legal counsel because he believed the former fiance was trying to extort him by threatening to publicly disclose information regarding potential NCAA violations related to extra benefits and inducements. On advice of counsel, the former head men's basketball coach continued his communications with the former fiancée. Based on a comprehensive review of the text messages exchanged with the former fiancée prior to August 2017, the hearing panel concluded that credible and persuasive information supported the conclusion that the former head men's basketball coach made payments to the former fiancée in direct proximity to her request for money to avoid disclosure of the potential impermissible benefits and activities. The former head men's basketball coach did not report the former fiancée's request for money, nor her threat to publicly disclose potential violations to the LSU Compliance Office, which the hearing panel found to be in violation of NCAA general principles of honesty and sportsmanship. Thereafter, after its assessment of the facts, the hearing panel found this to be a level 1 violation for the former head men's basketball coach. Additionally, from the beginning of the infractions case investigation on December 3rd, 2018, through August 20th, 2021, the former head men's basketball coach failed to cooperate in the infractions case investigation by delaying full production of records and documents. During the course of the investigation of this matter, he also knowingly provided false or misleading information regarding his knowledge of an involvement in possible NCAA violations. These actions violate NCAA bylaws of ethical conduct and failure to cooperate, and seriously undermine and threaten the integrity of the NCAA collegiate model. Therefore, after reviewing the full case record, the hearing panel found a level 1 violation for the former head men's basketball coach. The panel also found that the former head men's basketball coach was responsible for the violations in the men's basketball program. Due to his direct involvement in these violations, he failed to rebut the presumption of head coach responsibility and demonstrated he failed to promote an atmosphere of compliance within the men's basketball program. After reviewing the full case record, the hearing panel found a level 1 violation for the former head men's basketball coach. Finally, the hearing panel carefully considered the allegation based on a limited excerpt from a Yahoo Sports article that the former head men's basketball coach made an impermissible cash payment and offer of employment to an associate of basketball prospective student athlete number 2. The hearing panel did not find sufficient and credible information in the record to establish that the former men's head basketball coach provided recruiting inducements in the form of a cash payment to basketball prospective student athlete number 2, his family members, or associates. The hearing panel did find, however, there was corroborating evidence to confirm the former head men's basketball coach did make a permissible offer of a coaching position to the associate of prospective basketball student athlete number 2. I'm going to turn now to a portion of the record that concerns the assistant men's basketball coach number 1. With respect to the assistant men's basketball coach number 1, the hearing panel determined there was insufficient credible and persuasive information to establish that former assistant men's basketball coach number 1 provided recruiting inducements to basketball prospective student athlete number 1, his family members or associates. The case record did not contain specific corroborating information other than recollections of conversations between former assistant men's basketball coach number 1 and the cousin of basketball prospective student athlete number 1. The accounts of that situation were conflicting. Therefore, the hearing panel's determination rested on whom the hearing panel found to be credible. Based on the testimony contained in the case and at the hearing panel found former assistant men's basketball coach number 1 to be highly credible on his information regarding the allegation. After assessment of the facts, the hearing panel found no violation for former assistant men's basketball coach number 1. Let me now discuss other violations in the men's basketball program applicable to the institution. In around April of 2018, basketball prospective student athlete number 4 from NCAA Division I Institution D contacted former men's basketball student athlete at NCAA Division I Institution A about the NCAA basketball transfer process, and LSU was among the institutions to which the prospective student athlete was considering transferring. Former men's basketball student athlete at NCAA Division I Institution A was friends with the prospect's family and told the former head men's basketball coach he had influence over the prospect's transfer decision. Between April 2nd and April 7th, 2018, a series of text messages occurred between the former head men's basketball coach and former men's basketball student athlete at NCAA Division I Institution A. These were followed by April 9th, 2018 text message exchanges between the former head coach and the LSU Director of Basketball Operations and former men's basketball student athlete at NCAA Division I Institution A. Based on the content of the text messages, the hearing panel concluded that the former head men's basketball coach provided direction to the former men's basketball student athlete at NCAA Division I Institution A regarding the recruitment of basketball prospective student athlete number 4. This direction makes former men's basketball student athlete at NCAA Division I Institution A an impermissible recruiter. After its assessment of the record, the hearing panel found a level 2 violation for the institution. Let me now discuss a violation that's related to an impermissible in-person contact that the hearing panel found for the former head men's basketball coach and former assistant men's basketball coach. On February 28, 2018, the former head men's basketball coach and former assistant men's basketball coach number 1 traveled to Birmingham, Alabama to watch the boys' basketball state finals, which included a game played by basketball prospective student athlete number 3's high school team. Following the game, the former head coach and former assistant coach, along with family and friends, went to a local restaurant. While they were finishing their meal, the parents of basketball prospective student athlete number 3 sat down at their table. The former head men's basketball coach exchanged a brief greeting with the parents, and after a few minutes, the former head coach, assistant coach, and their group left the restaurant. Neither coach reported the encounter to LSU's compliance office, and a photograph, however, of the meeting did surface on Instagram a few days later. Based on the facts in the record, the hearing panel found the former head coach and the former assistant coach had impermissible in-person contact with the parents of basketball prospective student athlete number 3 on the same day in which the prospective student athlete competed. The institution self-reported this violation as level 3, and the panel did not find sufficient credible or persuasive evidence to support that the in-person contact had been prearranged or any other information that would support elevating this violation. Therefore, the panel found this to be a level 3 violation. I'm next going to talk about the portion of the case that concerns the institution's failure to monitor. The hearing panel did not find a lack of institutional control. LSU demonstrated it had a thorough rules education program for its representatives of athletics interests and men's basketball coaches. However, the institution did not actively and fully monitor and investigate the activities of a football representative of athletics interests, interactions with the family of a student athlete when there was institutional awareness of that connection. In addition, the institution did not meet its heightened obligation for monitoring the activities of a football representative of athletics interests regarding his interaction with student athletes during commingled celebratory activities following the winning of a football national championship. Further, the institution did not meet the monitoring obligations demonstrated in effectively monitoring the men's basketball program related to permissible recruiters. After its assessment of the comprehensive case record, the hearing panel found a level 2 violation. Let me now talk about penalties. The panel reviewed the full case record, of course, and classified this case as level 1 standard for the institution and level 1 standard for the former head men's basketball coach. Within the matrix of available penalties, LSU had already imposed several penalties. The panel accepted those penalties. The panel also prescribed further and additional penalties, which are detailed in the decision and also summarized in the attached news release. Let me read the list of the self-imposed penalties by the institution. First, relating to the football program. Vacation of all wins in which the ineligible former student athlete number 1 competed in the 2012 through 2016 seasons. During the 2020-2021 academic year, the football program imposed a post-season ban. LSU imposed a reduction in football scholarships by 8 over the 2021 and 21-22 seasons, 4 in 2021 and 4 in 2021-22. A 7-week ban on unofficial visits in football over the 2021 and 2022 academic year. A reduction in the total official visits permitted in football by 8 during the 21-22 academic year. A 6-week ban on telephonic communications with all prospective football student athletes during the 21-22 academic year. An off-campus recruiting restriction in football of 26 days in the fall of 2021 and 30 days in spring 2022. The former head football coach was prohibited from recruiting off campus for 30 days during September 2019. Finally, effective June 1st, 2020, LSU banned representative of athletics interest number 2 from all non-public areas of its athletics facility for 2 years. On October 1st, 2020, LSU disassociated representative of athletics interest number 1 for 10 years. Self-imposed penalties by the institution that relate to the men's basketball program are the following. A reduction in men's basketball scholarships by 1 over the 2023-24 season and by 1 over the 24-25 season. A 15-week ban on unofficial visits in men's basketball during the 2022-23 academic year. Reduction in the total official visits permitted in men's basketball by 2 during the 2022-23 academic year. A 7-week ban on telephonic communication with all prospective men's basketball student athletes during the 2022-23 academic year. An off-campus recruiting restriction in men's basketball of 20 days in 2022-23. An off-campus recruiting restriction for the former head men's basketball coach, former assistant men's basketball coach number 1, and the then assistant men's basketball coaches for 30 days in April through May 2019. The then men's basketball staff were prohibited from visiting certain prospective student athletes' high school, attending a certain prospective, a student high school, prospective student athlete's high school, attending his contests or otherwise communicating with him for 30 days in April through May of 2019. Finally, the institution self-imposed a financial penalty in the amount of $5,000 plus 0.5% of its average men's basketball and football budgets, based on the average of the men's basketball and football program's previous 3 budgets. Now let me go over penalties that apply to the former head men's basketball coach. And I think I'm almost done, so I hope you've been patient. Penalties for the former head men's basketball coach include a 2-year show cause order that shall run from June 22nd, 2023 to June 21st, 2025. Specific prohibitions in the show cause order include no off-campus recruiting activities during April or May summer evaluation and/or contact period. Reduction in official visits by 4 each during the 23-24 and 24-25 academic years. No recruiting conversations between September 1st, 23 and October 15th, 2023, and between September 1st, 2023 and October 15th, 2024. No unofficial visits from September 1st, 2023 through October 15th, 2023 and September 1st, 2024 and October 15th, 2024. A suspension from the first 10 contests of the first season of any Division I employment, which shall include any exhibitions or practice scrimmages. The panel also found additional penalties for the institution. Those penalties include a fine in the amount of 0.5% of the institution average men's basketball and football budgets based on the average of the 2 programs' previous three budget totals. Public reprimand and censure. There were detailed requirements regarding the vacation of records for the participation of ineligible former student athlete number 1. Vacation of team and individual record. The hearing panel provided additional details regarding LSU's self-imposed vacation of records penalty. These included 3 years of probation, which will begin at the conclusion of the probationary period assigned as part of the Committee on Infractions decision number 567, currently set to conclude on September 21st, 2023. During the period of probation, LSU will do the following. Information will provide information regarding all football and men's basketball prospective. Will provide to all football and men's basketball prospective student athletes in writing that the institution is on probation for 3 years, detailing violations that were committed. If a prospective student athlete takes an official paid visit information must be provided in advance of the visit or before the prospect signs a national letter of intent. LSU is to publicize information regarding the nature of the infractions on the athletics department's main webpage, in the affected sports programs, media guide, and alumni publication. It is to file an annual compliance report with the Office of the Committee on Infractions. And prior to the conclusion of probation, the president of LSU shall provide a letter to the Committee on Infractions affirming LSU's current athletics policies, confirming that LSU's current athletics policies and practices conform to all applicable NCAA regulations. So that concludes my remarks. I welcome your questions, and I'm going to turn this back to Amy.
Thank you, Judge Meyerson. We will now take questions from members of the news media. Judge Meyerson will answer questions specifically related to this case decision. Derek Crawford, NCAA Vice President of Hearing Operations, will answer any questions related to the independent accountability resolution process. So if you would like to ask a question and you're a member of the news media, please use the raise hand function at the bottom of your screen to indicate you have a question. I will recognize you by name, and then you may unmute yourself and ask your question. And I would ask that you please place yourself back on mute after you ask your question and while Judge Meyerson is responding. If you're participating on the call today and have a question, but you are not a member of the news media, please email your questions directly to me at borshoff@iarpcc.org. And that email address is also at the bottom of the news release that you received earlier today. So we will start. Michael Cauble, if you would like to unmute yourself, you may ask your question, please.
Yeah, I'm just curious, the length of the review in this case, what were the contributing factors to the extended amount of time before resolution?
The matter was referred to our hearing panel in September of 2020. And the review by the panel and largely my role involved addressing significant disagreements between the complex case unit and Coach Wade with respect to the production of digital records that had been requested previously by NCAA enforcement and then once again by the complex case unit. Those disagreements had to do with counsel's advice to the coach that certain documents and digital records need not be produced. That advice turned out to be inconsistent with the NCAA legislation. And so a significant amount of time was involved in resolving the disputes over the production of those records. Another contributing factor was that the vendor that the parties were using to maintain that digital information inadvertently disclosed records to the complex case unit before that disclosure had been approved. So the resolution of that disagreement also took time. So the answer to the question is significant time was taken up by disagreements over what records had to be produced consistent with NCAA legislation.
Okay, Wilson Alexander, please unmute yourself and you may ask your question.
Hey, Bruce, how did LSU's decision to fire Will Wade when it did factor into the final penalties here?
The decision to fire the coach was not specifically called out. And we did not specifically call that decision out in our identification of mitigating factors. So what the panel found were the mitigating factors that we put significant weight on were several fold, but largely the timely and significant self-imposed penalties that LSU implemented. If you look at the decision and the discussion of LSU mitigating factors, I don't think you'll see a reference to the termination of his employment. So that was not called out and identified specifically by the panel as a factor, but the other factors, as I can just maybe repeat myself, were the timely and significant, comprehensive, we thought, comprehensive self-imposed penalties that the institution implemented.
Okay, Dana O'Neill, if you'd like to unmute yourself and ask your question.
I have just a couple of questions, if I can, one related to the other. The first is just to clarify that that the show cause is related to the recruiting violations only, and that Will Wade can continue to coach. And the second is just as a follow-up, presuming that's the case, just if there's any consideration given to the fact that you guys use words like knowingly violated and against the integrity of the NCAA, quite serious allegations, but he already has a job, and in 10 games he'll be able to continue. And if, sort of any message that could be conveyed from such a penalty was considered by the panel as they were handing out penalties.
Well, let me answer the first question. I think as to the verbiage, I may turn that over to Derek Crawford, but the answer to the first question is that the coach has been hired by another NCAA Division I institution. He was hired in March of this year. Although it's not laid out specifically and in detail in our decision, we were aware of specific restrictions that institution placed on the coach in addition to the restrictions that are set forth in the show cause order. So the panel was aware that this institution that has hired the coach also placed substantial restrictions. We took a lot of comfort from that. And so the answer to your question is that the coach has been employed and is employed at another NCAA Division I institution. As to why we use the verbiage that we do, I'm going to ask Derek Crawford to speak to that, if he would like to.
Certainly, Bruce. I think, are you referring to the language in the show cause order?
Well, maybe ask the questioner which specifically maybe she can elaborate if she would be kind enough.
Right. I'm just trying to make sure I understand that the show cause, ordinarily the institution has to show cause, right? So it's to the verbiage of recruiting and being allowed to recruit. He is, after 10 games, eligible to coach. He can run practices. So the show cause is related to the recruiting violations as they're laid out by the panel.
Yeah, that's correct. So I think, as you know, Dana, the show cause, there are two types of show causes. One can be all athletic related duties. So effectively, the involved individual could not do anything of an athletic nature. Or you can have a specific show cause, which is partial and it limits athletic related duties. And so this show cause was the second one, not the first one. So he is suspended pursuant to the show cause and other restrictions that the hearing panel imposed. But once he serves the 10-game suspension and other restrictions, then he can have a full range of coaching and athletic responsibilities.
Thank you. Matt Norlander, if you would like to unmute yourself and ask your question.
Thank you. I'm wondering if the panel, as it determined this punishment for Will Wade, and there's a lot of talk about show cause for recruitment, considered the current nature of the state of college basketball recruiting and in an institution like McNeese State, where the transfer portal might be as important, if not more, than traditional high school recruiting, and if the restrictions around Wade right now also pertain to what he can or can't do in the transfer portal, or is this more narrow in its scope and only dealing with putting prohibitions on him when it comes to high school recruiting?
The role of the panel, of the hearing panel here was limited to considering the record before it. And within the scope of our jurisdiction, we were not permitted and did not consider broader necessarily questions to which issues that to which you're referring.
Okay, and then one quick follow-up. Considering how long the case actually took to play out, and you referenced earlier, the disagreements over what was permissible and not in terms of documents, and obviously there was some obstruction there. The panel, I suppose, was satisfied with the length of this suspension. Normally, when there's been cases of similar nature or delays in the past, punishments that would come down would sometimes be a bit more harsh, but the panel did not deem that necessary, even though this case dragged on literally years longer than many people anticipated.
No, I think the answer is no. We didn't, and although we were disappointed in the first phase of this case that took so long to resolve disagreements over document production, we didn't really question the good faith of the coaches' council. They had a perspective that ultimately I think was incorrect, but we didn't consider it to be bad faith on their part. We didn't consider the coach to have engaged in obstruction. And so the delay was unfortunate, but we didn't consider there was any bad faith on council's part or the coach's part that led to that delay.
Okay, thank you.
Billy Witz, please unmute yourself and ask your question.
My question was asked primarily by Dana, but can anybody elaborate on just what sort of I don't know, was there what sort of outreach McNeese State might have done, and if there was any communication, or was it just looking at what they, the 5-game suspension and other things that they put in place when they hired Wade?
No, I'm sorry that I cannot. We were advised by. Let me tell you what I can tell you. So we were advised by counsel for the coach back in March of his opportunity to coach for this additional institution. That letter brought to our attention the proposed restrictions that the institution was intending to impose. We also received letters from the athletic director and the president confirming that. So that's really all the panel. We didn't know the background, to answer your question.
Michael Cobble, please unmute yourself and ask your question.
Yes, I'm just curious from a IARP standpoint, the two differing sports programs, were they viewed as separate entities, or once you get the material, you have to consider it as a group decision?
It was referred to the panel, but both sports were referred to the panel, and the panel decided that insofar as there potentially were issues about that may impact the overall administration of this athletic program, the panel chose to consider them together. But the short answer to your question is that's what was referred to the panel. We were given information that pertained to both sports.
But you viewed it then as a institutional control issue as well, and considered them together?
Well, we made no finding about a lack of institutional control. So we did not view this as ultimately based on our review of the record. We did not find evidence of a lack of institutional control.
Right, but is that why they were considered together as one unit or presented to you together as one unit, I guess? Would these normally be considered separately, I guess is what I'm trying to figure out.
And I can't speak to why the infractions referral committee referred both. So that would be something that I'm not privy to. I know there was a letter that was sent to us several years ago that may address your question, but I just don't remember how specifically the issue you're raising was addressed in that letter.
Okay, thank you.
Rebecca Worrell, please unmute yourself and ask your question.
Yes, hey, so I was actually, this is just more for clarification on me so I don't say the very wrong things. They are currently serving a 3-year probation, or come September, they're going to serve a 3-year probation?
Yeah, I'm going to let Derek Crawford speak to that as to we do make reference to the termination of that suspension in the decision, but any specifics about that is really something that Derek, I think, has to speak to.
Certainly, Bruce. So to your question, the LSU is on probation currently for an infractions matter before the Division I Committee on Infractions. And that decision was released last fall. And they received, if I remember correctly, 1 year probation. That year of probation will end in September of this year. When that year of probation ends for the Committee on Infractions, then the 3-year probationary period prescribed by this hearing panel will begin. So they're right now 1 year. They'll finish that up in September, and then they'll have 3 years that will start in September and will go through 2026. So for a total of 4 years of probation for LSU.
Okay, perfect. I'm glad I asked. And that probation, that's where, let's see, that's a part of the probation is where you were saying they have to list that, you know, they are going through all of this. They have to do the compliance reports. I guess that's all part of that probation period.
Yes, that is correct. They are required to submit a report annually about their efforts to comply with the hearing panel's penalties, corrective measures, and so on and so forth. And so those are annual compliance programs that any institution that is placed on probation has to submit to the NCAA.
Whitney Thomas, please unmute yourself and ask your question.
Okay, I am going to I just kind of want to hound in on everything from a more news side. I am not a sports girl, so I'm just getting the grasp of everything with this story. I want to know about the IARP, just more so about the organization itself and how you guys carry out processes like this. If I'm not mistaken, I'm seeing that this case, you know, was open for 4 years. So exactly how you all hounded in on the conclusion and I guess just a breakdown. So I know that they're on probation right now. LSU is on probation. So just the means behind that. I think you guys said that Will Wade would still be able to have certain regulations as a coach, but I know he's not attached to LSU anymore. He's attached to McNeese State. So just sort of a breakdown in a news perspective and less, you know, of a sports perspective, if that makes sense.
Gee, there's a lot there. I don't know quite where to start. And I know Wendy Walters can speak to the first part of your question about the IARP, but I don't know whether, since there was so much important information that you're seeking for your purpose, that whether maybe there's an offline way to address all of that. I don't know whether, Amy, what's the right way to be responsive to this to Whitney, do you think?
Yes, Whitney, if you have background questions or information and you'd like to place that in an email to me at the borshoff@iarpcc.org email address, as soon as this press conference concludes, I'm happy to provide responses to those background questions if that's helpful.
Yes, ma'am.
Pardon me, Whitney, I will respond to your email then and answer your questions. And then Sheldon Mickles, if you would like to unmute yourself and please ask your question.
Yes, Mr. Morrison,
Yeah, hi.
can you hear me?
I do. Yeah, thank you.
Can you hear me?
I can.
Okay, sorry. My question about Will Wade's firing, did that mitigate the decision of the panel was taken long ago, but just maybe a follow-up on that, on the self-imposed one scholarship reduction the next 2 years. Did y'all think that was plenty enough, or did y'all maybe have some give and take about maybe more? Or because there's some people are going to probably think that's a slap on the wrist, although this whole coaching staff and team is different now.
Well, I think we looked at the panel plea, the complete package of self-imposed penalties by the institution, and we did give consideration to the actions of his now current employer. So I don't think there was one particular aspect of the penalties that we said, oh, gee, that's not enough. We looked at the entire package. And to answer your question, there was the significant discussion among the panel about that, of course. And for the reasons that I've just described, we came down on the side that we did.
Thank you.
Billy Witz, please unmute yourself and ask your question.
Hi, yeah, I wanted to ask you about violation the notice of allegation number 4 that was found that there was no violation there, and that's the one involving the Yahoo report,
Right. Right.
And I'm wondering if you, I guess if you had access to the wiretap transcripts at all, and if frankly, I guess what else you needed to make that case that ultimately you felt like wasn't there.
Okay. I mean, I don't want to speculate about, well, what if we had certain information? Would that have changed our decision? Let me try to answer your question based on the information that was available to us. I think that maybe is a better way to approach the answer to your question. So, we started with the standard that we had to operate, which is whether the information is available that is credible and persuasive, and the type of information that that people rely on in their affairs. And so we concluded that the excerpt itself, that limited excerpt from presumably from the recording, which I guess we can't even be sure of that, would not be the kind of information that would be credible and persuasive in the context that I've just described. And so what we were lacking was the complete article. We were lacking access to the recording, and we were lacking with respect to this allegation of some cash payment, any additional information that would support that. So we tried to approach it in that spirit, and in that spirit, we concluded that snippet of an article in and of itself would not be what we thought as a panel would be credible and persuasive.
If I can just follow up, I mean, is that, I mean, I guess pursuing the transcripts, or even better yet, the recording, is that something that's in your purview, or is that from the I guess the investigators? Is that something that I guess, did anybody try
I have to be careful because I don't want to speculate here, but the obligation to present that information to the panel was the obligation of the complex case unit. What efforts they made to obtain that, I apologize. I don't really have an answer to that. I don't know. And it was made clear, I think, to them that we were limited by the lack of that information. What they did to try to obtain the background information that you're describing, I'm sorry, I just don't know the answer to that.
Okay.
Ruth, if it's appropriate, I'll just answer that very quickly. The NCAA made a number of efforts to obtain that piece of evidence from the federal government, and they turned us down.
Oh,
So we did try, but we were not successful.
no, thank you, Derek, for helping me out there.
Thank you.
Certainly.
Billy, did you have another follow-up question? Okay. Just as a reminder, please use the raised hand function at the bottom of your screen if you have a question for Judge Meyerson regarding the case. Are there any further questions from members of the news media? Sheldon Mickles, please unmute yourself and you may ask your question.
Yes, yes, I was just wondering, just to clarify, I know Mr. Crawford said the football team will, that 1 year probation ends this September. Is basketball on right away now, or does theirs start in September also?
Do you want to expand on that, Derek? Can you expand on your answer there, if you would?
Yes, certainly. So you're correct in your question. The basketball probation does not begin until this September. The current probation is related to violation in the institution's football program. And so that's the probation. Well, you're in probation as a university, but the restrictions related to football. So when a probationary period occurs, the university is on probation. The penalties and restrictions go to a specific sport program that was involved in the violation. So those were the football penalties. The basketball penalties will begin, or at least they begin when the current period of probation starts, which is in September of 2023.
Okay, thanks for clarifying.
You're welcome.
Do we have any further questions at this time? If we have no further questions at this time, then we will conclude this call. Thank you.